Mahama has suspended Chief Justice Gertrude Tokonu after a preliminary investigation found sufficient grounds for an inquiry into her conduct. The decision, announced on Tuesday, follows 3 petitions calling for her removal. It was made in consultation with the Council of State in accordance with Ghana's 1992 constitution. Though the details of the allegations remain confidential, they have sparked considerable discussion about judicial accountability in the country. A 5-member committee has been formed to pursue further investigations. The Chief Justice will remain suspended until the committee completes its investigation, which could have significant implications for Ghana's judicial system. Gertrude Tokonu, the country's 3rd female Chief Justice, had occupied this position since June 2023.
Listeners, and also to the judiciary. And the MPP is very worried in a sense that the current president, as candidate Mahama, made a specific pronouncement in Akusumbo when my brother Rashid Tanko computer was present. And he made a statement that the lawyers within the NDC fraternity should prepare. He's going to make sure that he gets them to be on the bench, and many of them will get such opportunity. Little did we know that this is a hierarchy at which this particular discussions at Akusumbo is going to take and the shape. We all know that there is a case at the Supreme Court pending a decision to be made by the Supreme Court relative to the processes that has been started, Article 146 of the 1992 Constitution. And we know that when such matters are put before the courts, and every student from primary knows that we have 3 arms of government, that is the executive, the legislature, and the judiciary. It is somehow, in a manner looked at, that the executive is trying as much as possible to control the judiciary. As a result of that, President Mahama has gone ahead to suspend the Chief Justice using the process that has been started, which has been questioned to be decided at the Supreme Court. We all know that such decisions must wait until a decision is made at the Supreme Court before it proceeds. You cannot overrule or override on a pending decision and go ahead and make a pronouncement based on a process that you have started, which has been cautioned.
But if that be the case, the president will bear his own cross. Why not allow the process to run? If the president is found to have gone against what the law says, he will bear his cross. Why is that a worry for you, MPP?
You see, Kojo, what is worrying is that we are running a democratic process in Ghana. We are no more running a tyranny. We are not running a dictatorship. We are not running a coup of leadership. We are running a democratic, a constitutional democracy. And once the Constitution is very clear in matters that are pending for decision, the president ought to have been very careful and reserve his pronouncement in terms of proceeding on such a matter. Such decision of president to proceed to suspend the Chief Justice is to undermine the authority of the other arm of government. When you say the arms of government, you think that everybody would understand that every arm must be independent on its own. So it will be wrong and unconstitutional for the president to overlook a pending decision in the court to proceed to do what he did. And Kojo, there has been many objections to some of these particular procedures that has been used. It's been questioned. One of such is contained in the Supreme Court of Ghana Law Report 2005-2006 in Ajay versus the Attorney General and Akwiti. Very respectful lawyers, judges have made pronouncements. One of such pronouncements is Dr. Datiba, who is of the opinion that there has not been clarity in terms of the committee that has been set and even the establishment of the prima facie. So it's also established by Sophia Akufu, who have also indicated that such a matter must be relooked at. Because if you read entirely of the Article 146, it is clear that this committee that has been set up is an ad hoc committee. And the nature of the work of the committee in terms of the references and the work that they have to do is not clearly defined by the Constitution.
Mohammed, but in 2018, when the MPP government then was handling the petitions that were brought against the EC chairperson, Charlotte Osei, then went through the lay-down procedure as the Constitution directs, not so?
Kojo,
I want a yes or no, not so.
I am saying that these are two different cases. I cannot
how
use
different?
a yes or no.
No, but how different?
Yes, due process was used, and the due process that was used did not infringe on any unclear or described or prescribed procedure. All the procedures were followed, but in these particular circumstances, there has been questions. And that is why I am referring you to the Supreme Court of Ghana Law Report 2005-2006, where Datiba Sophia Akufo, Professor Georgina Wood, Professor Okran, all judges of the Supreme Court made pronouncement and clearly indicated that the terms of reference of the committee is not defined. And we cannot situate the committee, in this case, to define their own scope and terms of references. And that is why in that particular report, reference was made to Article 126 to 142.
And this was in which particular case?
Of Court Act to guide the processes of court proceedings and what have you. So there was a recommendation in that Supreme Court book that Article 145 and 146 should be looked at, and a clear procedure be given to the committee that is set up. Today, if they ask you, what is the procedure, the form in which the committee is going to do, the committee will certainly go and sit down and determine their own terms of reference or the nature of which they are going to handle that. So once there was a case at the Supreme Court pending a decision to be made, the President, His Excellency the President of the Republic of Ghana, should have exercised restraint to wait pending that particular decision to proceed. And if he has,
I want us to follow you in your argument. Which particular case was the Supreme Court handling when they made those pronouncements, as you referred to, in the law report?
I've not heard a question.
I'm asking that you refer to a law report provision, some conclusions in the law report that challenge the procedure. And I'm asking which particular case where is this that the judges were making reference to this, so that we can all go and check and follow what you're saying.
Reference Ajay versus Attorney General and Akweti.
Okay.
And this was relative to a similar matter. And these judges were expressing their view by way of report, and they were all agreeing to the position of Dr. Datiba in terms of the judgment that Datiba and the conclusions that Dr. Datiba had reached. And in fact, if you read it carefully, Sophia Akufo JSC, who is former Chief Justice now, agreed to the position. Okay. You also read that you see one of the judges, Georgina Wood, who also a former Chief Justice now, also agreed to the conclusions of Dr. Datiba. Professor Okrai, who also agreed to the conclusions of Dr. Datiba. It was very clear.
Okay, let me bring in Dr. Rashid Tanko Computer. He's the Deputy Director of Elections for the NDC. Doc,
he was part of their election directorate, and Tanko Rashid is not a new person to the Directorate of Elections of the.
Well, that is not my question to you. I mean, I don't want us to engage in anything that we cannot prove. So go straight to my question.
And knows everything about Amadou Sule. You should not be surprised. Again, I also want to put it on record that the only political appointee we all know that is in Supreme Court now is Gabriel Kwama, who was a General Secretary of the People's National Convention. Everybody knows that the People's National Convention.
I don't know of that. So your statement of everybody.
The legal luminaries. It is not clear who establishes the prima facie. You can't say whether it was the Council of State decided that there was prima facie. If they can advise, and their advice is not compulsory to be taken by His Excellency the President of the Republic of Ghana. He could take his own decision without necessarily looking at what judgment that the Council of State has passed. And you cannot also say that the members of the Council of State, all of them had agreed. And I don't think that Madam Sophia Akufo will agree to that particular point in point for what he's saying. So I think that the harm has been caused. It's left with us as Ghanaians and the New Patriotic Party and other well-meaning Ghanaians to get up and stand and fight for the Constitution of the Republic of Ghana. I don't think that this is what should be happening in our judiciary system. What happens to the independence of all the arms of government? What happens to that? I think that there should be a closer look, and I don't think that this is the way for us to go.
Well, quite interesting that the process that you used in dealing with Charlotte to say, when the same constitutionally prescribed processes are being used on the Chief Justice, you find issues with them. But Tanko Rashid, so
Kwame Nkrumah we no koye constitutional review. And one appointed also a president for life. Your mama a constitutional review. And come on here say because we hear judicial interpretation to the effect say obet me ako 2 times or 3 times it is no constitutional review na you bisa question and we see history is repeating itself. Kusasi fonto kwa sorry 58 enu mu na bombing ba ye kurungugu kusasi fonto kwa sorry sabri ama ho IGP akwa me atuntuo tienio San wo yi judge for na we jo mama wi a onwie etu ahwa omo ya ade bi omo the list bi abeto say the Supreme Court no Akufo-Addo na appointed them more etu ombe yi judges ni bi just like Kwame Nkrumah did. Now Kofi you moving free wo e dey na see Kwame Nkrumah yeah within 1 year na pain kotokamo e didn't to form more fire. Etu pese ohunu de ntia Kwame Nkrumah wo ye na nkofo jubilate a it got to a point me ankasa me Nkrumah Santiago na kobi e o pese Kwame Nkrumah no a very fantastic leader but no one excesses ahemfo no mo support ni nyina no omyetu ahemfo no di CPP nkofo ne ko di hene etimi Nkrumah se nkofo bebe di hene no mo yamfo mo ayamamre kwaso ye pagya won sa CPP rally and Kwame Nkrumah your mama ye the same thing. Now the man only funny thing. Come Kwame Nkrumah ye Bombay no. Kurungugu Bombay celebration the next year no. Na ye Dr. Mahama Dubaumia papa. Ana ne di Kwame Nkrumah ani mo ye Kurungugu ayi bokuo. Tieni o. Dr. Baumia papa. Ana ne di Kwame Nkrumah anim. Satam na jo mama papa. Eye minister for Kwame Nkrumah. Eti oyi ni free one no de Dr. Baumia papa bai. Chenio, history is repeating. And then you want to say Dr. Mahama Dubaumia, when you call your mama, and they are the closest contender. Our brother me and papa, they were the closest contenders. History is repeating itself. More fire. After your bedroom baby, your mama say, Omuko Kotua, Omu winning case. Mobakaya, 2009. Tama Professor Mills winning. Anna, a year the then chairman for a year in DC. A Friday say, Kwabeneje say, Omu case Kokotua, Omu winning, a Justice Georgina Wood, and in the court when I said a woman winning. There is so many ways to kill a cat. Okay, Adientia, Adiatin almost suma Brantian can think as young court, a Supreme Court from Cochiamo. Emma Judge Sigane. More fire. So NDC has sa ayini say, Omunya ba ayamemuma. First thing they want to do is to touch the courts. No mudo omunko for besiwo. Tienio. Because omoko case huwa buga. Me sure so what you say omo say NIB case e de na no mkofa dubu ahio say wan bi no. Me sure so what you say omo say ade no kura hwi ni mo go post no mo shift etine say prayer me no ka say enipa wo hwe eye iyokusu no ye yi na fro sisi abese ne ko eye NIB because of sasa adwuma nsoni eti wo mko court wie ni asi ye mpene dia ene jo mama so be yi Chief Justice it will gina a petition miansa petition omo trust omutum kofi na ba ko bi wo ye friend than Euphoria or your lawyer ni enkomo bi wo akire true than Euphoria no or representing a client bi na the client no na sikasem bi wom ana ko fa he na ko wie he ye be dis ankomo na nya for the public kofi it is a Mahama say obepamu chief justice yadi ye tunefo yesere no Kwame Nkrumah pamu bio and the justification they are using and this for it is amoka kire yese ekufo do you AEC you can say EC which is Charlotte said it is a musumu ba there is a moral justification say mo beyi chief justice said first of all the position of chief justice it is not comparable to that of a EC chair because there were 3 arms of government. Chief justice is one of the arms of government which is an independent arm of government. Now Musi ye Charlotte said it musumo ba mo be chief justice said na mo nim se be nkwase asam sa na mo be to aso dia ene mo nya ba kufa no to aso
more fire
Kobi Sankufa do yene nra woni be di atuo wo mo ye no kura wo mo se na ya de tantan na nyansa bia nim I never supported it na se mo so mo nim se sabi nsem hunu sa ana mo ba be di a ene ye to ba ma mo ye den if say ye to ba ma jo ma ne so wo ba with fresh air or be may be different it is a mobile na nsem hunu ye di ne nra eno ana mo so mo be di a Yankan Sisubia, so almost when a Kufado by we Domelevodi. The first person I will buy, Auditor General, what Tiakunyamu, or in a dear Professor Mills.